Judge, I think you're on mute.
You are absolutely right. So I will ask again, could you please open the proceedings, Madam Registrar?
Thank you so much, Justice Witt, and it's a pleasure to see you. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Guyana. Judgment delivery in the Consolidated Appeals GYCR number 1 of 2022 between Orwin, Hinds and the state, and GYCR number 2 of 2022 between Cleon, Hinds and the state. The members of the delivery panel are Mr. Justice Witt, presiding judge.
Good afternoon, and may I also make use of the opportunity to wish you all a happy new year. We are in January, so I think it's still possible to say so, and certainly a healthy new year.
Thank you, Judge. Madam Justice Rajnath-Lee.
Good afternoon, everyone, and I believe Justice Witt speaks for all of us. Thank you, Judge.
Mr. Justice Barrow.
Good afternoon, all, and my sister is quite correct. Our brother speaks for us all.
And Mr. Justice Burgess.
Good afternoon, Counsel, and I join my colleagues in saying that Justice Witt speaks for all of us.
May we have the appearances, please? Thank you.
Good afternoon, Your Honors. Arudranath Gosai for the appellants Orwin Hinds and Cleon Hinds. I also take this opportunity to extend best wishes to Your Honors and to the administrative staff of the court.
May it please Your Honors, Diana O'Brien appearing together with Mrs. Tishana Lake for the respondent. A very happy new year to Your Honors and to my colleague, Mr. Gosai.
Thank you. The judgment will be delivered by Justice Barrow, who wrote the judgment, which we all signed, also the president, who is unfortunately not present today. Justice Barrow will deliver the judgment in the form of a summary.
Thank you, Chair. Brothers Orwin Hinds and Cleon Hinds were convicted for the murder of Clementine Feed2 Paris for the payment of money contrary to Section 101D of the Criminal Law Offences Act. The trial court imposed sentences of 81 years without eligibility for parole before 45 years. On appeal, the Court of Appeal reduced those sentences to 50 years. The brothers then appealed to this court. On conclusion of the hearing, the court dismissed the appellant's appeals against conviction for murder, but reserved its decision on the appeals against the sentences imposed by the Court of Appeal. The court, in this judgment, now delivers its reasons for its decisions to uphold the appellant's convictions and its judgment on their appeals against sentencing. The court noted that the convictions of the brothers were primarily based on their written and oral confessions, and additionally, in relation to Orwin, on the evidence of an eyewitness who identified him on an identification parade. In his written statement, Orwin described the plan that was hatched with his brother and two other men, Dutchy and Black Boy, to kill the deceased, an elderly woman, for a sum of money. Orwin said that he obtained the gun and gave it to Cleon, who then lent it to Black Boy. He said that he and the other men went along with a driver to the deceased's house, and before the killing, he told the men that he wanted no part of it, but eventually was persuaded to go. He and Dutchy entered the house, where they passed a man on the stairs. He said that Dutchy told him to restrain the man, which he did, and he then heard 2 shots. They left and heard the following day that Mrs. Feed2 Paris had died. Later that day, Orwin said that Black Boy gave him $80,000 and Cleon $5,000. In Cleon's written statement, he confessed to being told about the payment to murder Mrs. Feed2 Paris and his decision to lend the gun to the organizers to, quote, get in on the business, end of quote. He also said that he drove around the house after the murder and that he collected money for the killing. The court found that there was nothing in the appellant's arguments which could undermine the probative value and weight of their confessions. Counsel advanced the argument that Orwin was beaten to give his statement and it was therefore untrue. The court found, however, that it was virtually impossible to overcome a jury's decision as to who or what to believe unless it could be shown that their decision was perverse. In the present case, the reasonableness of the jury's decision to doubt the appellant's allegations could not be doubted. As for Cleon Hinds, counsel submitted that the trial judge ought to have warned the jury of the danger of relying on the statement since there was no other confirmatory evidence. The court found that in the circumstances of this case, there was no requirement in law to deliver such a warning. There were other arguments raised, but these were of little substance and did not warrant fulsome consideration. On the issue of sentencing, the court first noted that the murder fell into the class of the worst murders under Section 101 of the Act. These are far more violative of the society's peace and order, and they are subject to the special sentencing regime set out in Section 100A(1)(a). That section provides that a convicted person shall be sentenced to death or imprisonment for life. Where a sentence of life imprisonment is imposed, Section 100A(3) states that the court shall specify a period which the person should serve before becoming eligible for parole. In the case of the gravest murders, the period shall be not less than 20 years, and in the case of other murders, the period should be not less than 15 years. The question of whether Section 100A(1)(a) creates a mandatory sentence and whether, if it does, such a sentence is constitutionally compliant were not raised, and therefore the court did not pronounce upon them. The appellant's argument was that the Court of Appeal erred in law in failing to impose, quote, the sentence as prescribed by Section 100A(1)(a) of the Criminal Law Offences Act, end of quote. Counsel's view was that a lien against the Crown established that a sentence of life imprisonment amounted to a term of years of imprisonment. The thinking was that since in the context of that case, since life in the context of that case was held to be a term of 25 years, the sentencing court ought to have imposed that sentence in this case. This court, however, stated that it must be remembered that life imprisonment means a sentence of imprisonment for life, and the convicted person has no right to be released. The fact that the parole system can result in the convicted person being released and not dying in prison did not alter that duration of the life sentence. The other dimension of counsel's argument was that the sentence of imprisonment for 50 years was in practice a more severe sentence than the maximum sentence of imprisonment for life. This court found that a sentencing court has no power to impose a sentence that is intended to be more severe than life imprisonment, which is the maximum sentence. The previous exposition produced the following important conclusions in respect of the class of murder in question. 1, a sentence of life imprisonment is the maximum sentence. 2, it carries with it a statutory entitlement to be considered for eligibility for parole. 3, that eligibility arises after a period of 20 years in Guyana or such later period as a court may fix. And 4, that the court has no power to impose a sentence of 50 years imprisonment or any determinate period that would exceed the sentence fixed by the Act. In this case, setting a minimum period that must be served before there could be eligibility for parole was therefore a mandatory obligation in which the Court of Appeal did not fulfill. Also, as noted in August and Gab against the Crown, it is an exercise which satisfies the penological objectives of punishment and deterrence. The court found that the period of eligibility for parole should be set at the minimum of 20 years for both appellants, and mitigating factors, for instance, Cleon's minor role in the killing, could not operate to reduce that. The court was therefore satisfied that the sentence of 50 years imprisonment imposed by the Court of Appeal must be set aside. Each appellant is sentenced to imprisonment for life and shall become eligible to be considered for parole after a period of 20 years imprisonment, including the time spent on remand awaiting trial. Thank you, Chair.
Thank you, Justice Barrow. Any comment on the side of the attorneys?
Thank you, Your Honors. No comments from the appellants, please, Your Honors.
Okay.
Much obliged, Your Honors. No comments on the side either, please, Your Honors.
Okay, thank you very much. That will then conclude the delivery of this judgment. So, Madam Registrar, could you please close off?
Thank you, Mr. Justice Witt. Thank you, Madam Justice Rajnatley. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Burgess. Thank you, Counsel. And a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.